right, let's start with this developing story this afternoon. The Section 89 panel chair, former Chief Justice Sandile Ngcobo, will not oppose President Cyril Ramaphosa's challenge to its report. Ramaphosa is taking the Phala Phala Report, which he says may have, which says, in fact, that he may have violated the Constitution on review. In the papers, the president accuses the panel of misunderstanding its mandate when considering the matter. Let's now speak to senior legal analyst, Advocate Romeo Nthambeleni. Advocate Nthambeleni, always a pleasure to speak to you. Are you surprised by this? Because others had indeed said that once the panel wraps up its work and hands over the report to Parliament, that's it for them. They can no longer get involved. And now they're saying that they're not opposing this particular review. Your reaction?
Yeah, no, good evening to you and the viewers, Bongyo, and thanks for having me on the program. Indeed, it's quite correct that once the Section 89 panel submit the report to Parliament, I think that is the end of their duties insofar as the Section 89 panel is concerned. And again, this talks to the integrity of the chairperson of the committee, the former Chief Justice Sandile Ngcobo, to say that when there are no issues to actually raise and to challenge what the president is actually bringing on the papers, there's no necessity for them to bring such an opposition to the papers that has been brought by the president to review the Section 89 panel findings.
What happens now? How do you see this one playing out? Can we potentially see maybe the speaker deciding not to oppose it and choosing to abide by the court's decision?
Yeah, I think you're right, Bongi. Also, I think that the speaker will follow suit, because if the speaker was opposing it, she was going to also have given the instructions to the chair to actually prepare papers in opposition. So I think you're quite correct that we are going to see the same pattern being followed by the speaker in relation to the opposition of this review as it is being brought by the president to the Constitutional Court. Then
how do the opposition parties treat this one, when it comes to the proceedings themselves? Can they get involved?
Yeah. I think the opposition parties, we're going to see them actually opposing and then raising their grounds of opposition on the papers and instructing actually their lawyers to actually file the response in relation to the review as it is being brought by president, because I think they're insisting on their position that the findings of this Section 89 committee were actually correct. So if you do that, you have to actually file your papers so that the Constitutional Court will have the benefit of actually having to hear both sides before they make a determination of what it ought to be in the end.
Now, in the papers yesterday, the president says that, any steps taken by the National Assembly pursuant to the report are equally unlawful and invalid. How much of a spanner does this then mean for the parliamentary process, which we're expecting to sit next week?
Yeah. Look, I think, you are correct to say that it throws the spanner to the works, but you must remember that a review is not like an appeal of a decision of the court. So technically speaking, a review does not stop the parliamentary process to actually proceed. But the president will make out a case to say that because this matter has been looked at, we need to give the ConCourt an opportunity to look at it and make a determination before we put the cart before the horse. And that will be also a valid argument as well to say that if the Constitutional Court threshes out these issues and we have a clear directive of where we're actually going, that is going to be very much important. And another important thing, Bongyo, is that the panel's report is not like a decision of the court. So if the Constitutional Court says that the president has violated the Constitution, then you're talking of a different ball game altogether. So I think that is why it was a prudent and a wise decision for the president to take this matter to the Constitutional Court, because it is the only apex court in the country that is clothed with the authority to interpret the Constitution of the Republic.
I suppose then that process will be key when it comes to finality as well, around the legalities when it comes to some of the processes he's raising issues with when it comes to this panel.
Absolutely, you're quite correct, because many constitutional findings were made, and hence the president was having a gripe with it to say, how do you make constitutional conclusion that I have violated the Constitution, and the Parliament must take the process of removal of president in terms of Section 89 without that being determined by the court. So those are the grounds that the president has actually reviewed this Section 89 panel and said, you have exceeded your mandate in terms of what you were requested to look at in terms of the notice of motion that was brought by ATM. So you're quite correct to say that is very much important to bring finality and also to put the matter in relation to the Constitution and the requirements of the performance of a president in office.
And there's one thing, though, that I'd like some clarity on, because one of the things that the president talks about is the distinction between information and evidence. And he says that, evidence has probative value. Information sometimes has a probative value as well, but not always. The panel never sifted through information to focus on evidence. How crucial is this when it comes to arguing this for this particular review?
Yeah, but Bongi, that is very important, because in terms of the law of evidence, there's a distinction between information and evidence. And the the rules of evidence in terms of information requires, for you to actually tell the source of where the information come from, interrogate the source of that type of information in order to have probative value, when you bring it before the court. And you can see from the statements that the panel was looking at, unsworn statement, unsigned statements, and then press releases, and this creates problems in terms of them carrying probative value. That is why the panel indicated that what they have, it's hearsay evidence, and they made that concession on the papers. And the question that we should be asking ourselves is that how much value does hearsay evidence actually carry? Because you cannot deal with hearsay evidence without actually subjecting a person that has been charged before cross-examination. That's when you'll be able, under the principle of Criminal Procedure Act, to make a proper determination whether you have a prima facie case or not. You cannot determine a prima facie case without listening to the evidence of a person who is accused. And the Constitution is very clear, Bongi. It says that every accused person is presumed innocent up until they are proven guilty in an open court of law.
So I suppose then that, the strength of the hearsay evidence, as you say, has now been weakened, especially because this was not a full-on ad hoc committee that would have then heard from the president and all of that. So what then becomes his chances of getting this particular report reviewed, and subsequently we start seeing then another process unfold here?
Yeah, look, it's good. The prospects are good because, hearsay evidence has got its own challenges, as we've already, indicated the challenge of hearsay evidence under the rules of evidence, in our law. And, the basis of those prospects is that, as you have said, that the committee did not have the powers to subpoena the witnesses and able to actually, call the president and, make a proper finding and a determination based on evidence from both sides. So that principle of audia literam partem rule in law is very, very much important, that when you had both sides, then you can be able to make a proper call and a determination. And that is done in a court of law where evidence is weighed, and then there is a determination whether there is a case to answer. And that will be done by the NPA when all these 8 other agencies that are investigation have made a determination that indeed there's a case to answer. And without that, then we'll again be putting the cart before the horse, because that determination must be made by the NPA. And the NPA will then decide whether there is a case that they're going to be able to prove beyond reasonable doubt. And then when they do that, then they can be able to bring an indictment, and then the president can be able to answer to the charges. And once the president has been found guilty, then the parliamentary process can be actually be made for the removal of president under Section 9 of the Constitution, Bong.
Yeah, it looks like things are not as clear-cut as some would have thought that it is. Thank you so much for helping us comb through this and make some sense of it. Do appreciate your time. That is Advocate Romeo Nthambeleni, Senior Legal Analyst, trying to, really help us make sense of the developments around this Section 89 panel.